In this video, I'm going to walk you through the key state laws every small business owner needs to know before hiring in Florida, so you don't become another cautionary tale. I'm Santiago Cueto, board-certified international business law expert and best-selling author. In my nearly 30 years of defending employers against all kinds of employment lawsuits, I've developed a winning strategy for hiring employees the right way. Now, here's what most business owners don't realize. Florida might be known as a business-friendly state, but when it comes to employment law, there is a minefield of regulations that can catch even the most well-intentioned employers off guard. Unlike some states that have their own comprehensive employment law framework, Florida operates as somewhat of a hybrid. You're dealing with both state-specific requirements and federal laws that apply differently than they might in other states. Let me give you a real-world example. Last year, I consulted with a small restaurant owner in Miami who thought she was doing everything right. She paid her servers minimum wage, she had workers' comp insurance, and she even had an employee handbook. But she made one critical error with how she classified her delivery drivers, and it ended up costing her nearly $40,000 in settlement and legal fees. The problem? She didn't understand the nuances of Florida's independent contractor rules. And that's just one of several traps that can derail your business before it even gets off the ground. Let's start with something that seems straightforward, but actually isn't: minimum wage. Now you might be thinking, Santiago, I know what minimum wage is. I just pay the federal rate, right? Wrong. And this is where so many Florida employees stumble right out of the gate. Florida voters approved a constitutional amendment that's gradually increasing the state minimum wage every single year until it reaches $15 per hour in 2026. Now, as of September 2024, Florida's minimum wage jumped to $13 per hour. That's well above the federal minimum of $7.25. So if you're still paying based on federal guidelines, you're already in violation. But here's where it gets even more complicated. Now, if you employ tipped workers, bartenders, servers, valets, there's a separate minimum wage calculation. Florida allows a tip credit, meaning you can pay tipped employees less than the standard minimum wage as long as their tips bring them up to that threshold. But you have to do this calculation correctly, and you have to notify your employees in advance about the tip credit. Miss this step and you could owe back wages. And here's the kicker that catches people every year. These rates change every September 30th. So you need to mark your calendar, adjust your payroll, and update any employee notices. Because the Department of Economic Opportunity doesn't send you a reminder, and ignorance is not a defense. Now, if you're finding this information valuable and you want to make sure you're protecting your business, do me a favor, hit that like button right now and subscribe to this channel. I break down complex legal issues into practical advice you can actually use, and I don't want you to miss the next critical information in my next videos. All right, let's talk about the mistake that costs Florida businesses more money than almost anything else: misclassifying employees as independent contractors. I get it. Hiring independent contractors seems simpler. No payroll taxes, no workers' compensation insurance, no employee benefits. You pay them for the project, they handle their own taxes, everybody's happy. Except when the IRS and the Florida Department of Revenue come knocking, nobody's happy anymore. Here's the truth. Florida doesn't have its own independent contractor test written into a statute. Instead, courts and agencies use a variety of factors, and they're looking at the reality of the relationship, not just what you call it a contract. You can put independent contractor agreement in 72-point font at the top of your document, but if the working relationship looks like an employment relationship, you've got a serious problem. Let me break down what actually matters. The agencies look at control. Do you control when, where, and how the person works? If you're setting their schedule, requiring them to work from your office, and dictating exactly how they perform their tasks, that's screaming employee, not independent contractor. They look at whether the person is engaged in an independently established business. Do they have multiple clients? Do they advertise their services? Do they have their own business insurance and equipment? Or are they working exclusively for you using your resources? They also consider whether you're providing benefits, whether you can fire them without cause, and whether the work they're doing is integral to your business operations. And here's a critical point specific to Florida. If someone is doing work in the construction industry, Florida has an even stricter rules through the Division of Workers' Compensation. They presume workers are employees unless you can prove otherwise with very specific documentation. The consequences of getting this wrong are severe. We're talking back payroll taxes, penalties, interest, potential workers' comp violations, and even personal liability for business owners. That restaurant owner I mentioned earlier, her delivery drivers were classified as independent contractors, but they drove company vehicles, wore company uniforms, and worked set shifts. The state looked at that arrangement for about 5 minutes before reclassifying them as employees. Now let's talk about something that seems minor but can result in significant fines: mandatory workplace postings. Now, Florida law requires employers to display certain notices in a conspicuous location where all employees can see them. And no sending them a PDF, that doesn't count. At minimum, you need the federal posters, things like the Fair Labor Standards Act, OSHA Workplace Safety Information, and the Equal Employment Opportunity Commission poster. Well, Florida adds its own requirement on top of that. You need to post information about workers' compensation, unemployment compensation, and Florida's minimum wage notice, which, remember, changes every year. Now, if you have employees who don't speak English as their primary language, you may also need to provide these notices in their native language. And certain industries have additional posting requirements. For example, if you're in agriculture or farm labor, there's a whole separate set of notices required by Florida statute. Now, the Florida Department of Economic Opportunity offers a combined poster that includes several state-required notices in one document, which makes compliance a little bit easier, but you still need to make sure you're covering all federal requirements. And remote workers, you need to provide them with electronic access to these posters or mail them copies. Now, here's what makes this particularly tricky. Posters get updated, laws change, phone numbers change, and agencies reorganize. If you put up posters 5 years ago and haven't looked at them since, there's a good chance you're out of compliance right now. Look, I know this feels overwhelming. You started a business because you're passionate about your product or services, not because you wanted to become an expert in employment law. But here's the reality. These aren't optional guidelines. They're legal requirements, and the penalties for non-compliance can devastate a small business. The good news? Now you know what to look for. You know that Florida minimum wage increases annually. You know that independent contractor classification is about the actual relationship, not just the paperwork. And you know that keeping your workplace postings current isn't just a suggestion. Now, if you found this video helpful, make sure you like and subscribe to this channel. I post regular content breaking down complex legal issues into practical strategies you can implement in your business today. And if you need specific guidance on your situation, consider consulting with an employment law attorney licensed in Florida, because an ounce of prevention really is a pound of cure. I'm Santiago Cueto, your Florida business attorney. Be sure to watch this next video for more business law insights.